going, etc. I'm happy to take questions as we go through, as we're a small group. The purpose of the discussion is really to focus on third-party funding in the context of arbitration. What I'm aiming to do is to explain why third-party funding in the context of arbitration has been remarkably successful, why many of the constraints that you find in the context of litigation funding are not to be found to the same degree in arbitration funding. Also and predominantly, that if one looks at the amount of money that is involved in some arbitration claims, why third-party funding represents a remarkably good business proposition. And I thought the best way of displaying that was, first of all, to look at some of the cases that are currently being arbitrated. Now, this is from 2015, which is the last, if you like, scorecard that was produced. I can't think of a case before the courts of Australia, or for that matter, other courts, that approach the value of these cases. So these are cases that are proceeding either by way of investment treaty arbitration, and for the purpose of this talk, I'll just assume that you understand what an investment treaty case is, or by way of contract arbitration before international commercial arbitration tribunals. If you look at that and you see that obviously the amounts even just amongst those top 6 arbitrations are well over $30 billion, collectively well over, anyone wants to do the maths, probably $300 billion. Now they are claims, they're not necessarily the judgments. But before I came here today, I was reading in a news service, and the news service was reporting on an award that had been handed down against the Republic of Argentina. That award was for $350 million, and they were seeking to set aside that award on the basis, interestingly, that what had occurred is that the claimant had been funded. They said, hang on, the claimant's been funded. And what they sought to do was to say that is an illegitimate use of the investment treaty process under ICSID, so the International Convention for the Settlement of Investment Disputes. They said, because that's an illegitimate use, because the party who suffered the loss wasn't actually this claimant anymore, it was Burford Capital, who were paying for the arbitration and running the arbitration. And they said, this award should be annulled. So there's a limited appeal mechanism under some investment treaty arbitrations that allow you to set it aside. The annulment committee said no. The annulment committee said it was fairly and appropriately vested with the claimant, who had then sought funding. So Burford Capital, whose return on that $350 million award was $107 million, was entitled A, to hold on to it, and to proceed to enforcement of that award. And of course here we are examining that the parties on the other side, for the most part, are state parties. Enforcement, whilst not guaranteed, is certainly a process where you can be reasonably comfortable that at the end of the day, and this Burford Capital case took 11 years, at the end of the day, you're going to get paid. So Burford Capital had booked a profit of, it worked out to be about 770% on their investment. Not only that, and interesting, at least to me, was that Burford Capital got the award and then an annulment application was made. So there's obviously some risk that they might have lost that award. What Burford Capital then did was factor, and so they sold on their theoretical $100 million share of that to another party. And they sold it for $100 million, and they said, if it gets annulled, you get your money back. But we're selling it on. So they sold it on, took the money, and now they get to hang on to the $100 million. It'll be up to someone else to actually progress to enforcement of the remainder of the arbitration award, which is obviously their share of the 100, plus the claimant's share of the rest of the 350. So it shows you, A, the sort of money that we're talking about, B, that sometimes people claim $1 billion and they recover 300 million, or they may even seek to make a claim even much larger than that and recover a much smaller amount. But legal costs, and even legal costs that are in the millions and approaching 10 to 13 million, which I think some of the average investment treaty cases can run to, still represent a very significant return. So why do you use arbitration when you're dealing with a cross-border dispute? And I know some in the audience are very familiar with why arbitration is preferred. This is what's regarded as the sort of preeminent survey of attitudes towards international arbitration of hundreds of users by Queen Mary. They conduct this survey every 2 years. So Queen Mary did a survey. They look and say, well, how do you go about resolving cross-border disputes? The vast majority is either arbitration or arbitration in conjunction with other forms of ADR. So, got a cross-border dispute, overwhelmingly parties prefer to resolve it by way of arbitration. And why? And again, I think the concern of one of our colleagues here can be neatly summed up by show me the money. And it's about enforceability, because a piece of litigation or arbitration is a meaningless exercise unless you're going to get paid. At the end of the day, if you're seeking to enforce rights or remedies, unless an empty verdict that doesn't allow you to enforce that award or judgment is a waste of everyone's time and costs. And a litigation funder, particularly, or third-party funder, would say, what's the point? And that's the question that any third-party funder is going to ask. They're going to say, sure, I understand you've got a very good case. Yes, you've got a 60% chance of winning, but where's the money? And if you're proceeding in a cross-border context, that is where the assets are likely to lie outside of the domain of the dispute resolution provider, then arbitration realistically is your only choice. The reason that arbitration is favoured is this thing called the New York Convention. New York Convention allows for enforcement in over 165 countries around the world. And enforcement, although this is only marginally overstating it, should be a rubber stamp, because the award that you get from an arbitrator in Mongolia is enforceable before the courts of New York, before the courts of Australia, England, India, wherever. So that's why people go for arbitration. And that's why, obviously, if you're a funder, you look at it and you say, okay, first of all, show me in this cross-border dispute you've got an arbitration clause. Show me that that there are assets that I can recover against, and show me that you've got a good case. You start asking those questions, and then you get to an answer of saying, okay, I can see why. One of the issues that is seen as one of the least favourable characteristics of international arbitration is seen as cost. So cost doesn't rank up there incredibly highly, and that's because international arbitration is expensive. Now, most parties will complain about cost, whichever mechanism you use. So whether it's litigation or arbitration, both are seen as expensive, time-consuming, etc. The advantage that can be said for arbitration is that the prospects of appeal under New York Convention is very limited. So it costs you a lot, but you get a result, and having got that result, the prospects of it going on appeal are very small, and the prospects of enforcement are very high. But cost is an issue, and that probably is the reason why parties who have a good case turn to third-party funding, because they go, look, it's going to cost me a lot of money, I don't have a lot of money, or I want to take it off balance sheet. So yes, I've got a good case, but I'm not in the business of running disputes. How about I just take it off balance sheet, give it a share of the upside to a funder, and off we go. Any questions on that? So are parties in the context of international arbitration aware of third-party funding? And the interesting thing is the growing awareness. So this survey was done in 2015, then again it was done again in 2017, is that right? 18, sorry. And there's been a significant increase in both the knowledge and availability of third-party funding, and there's been a significant increase in those participants in arbitration who are taking advantage of funding. So that's what's happening, is that there's a growing development towards use familiarity and recommendation. They say, oh, if you look back here on how familiar are you with it, 56% are aware of it but haven't used it in practice. So if you're a funder, you look at that and you go, okay, these are people who are involved in international arbitration but are not using it yet. So in that context, untapped. 26%, yep, did use it, and 16 have, 26 have seen it used, so probably they were on the other side to it being used, and only a very small percentage now not aware of it at all. And then other forms of third-party liability insurance, etc. Again, a very, very high level of knowledge about those mechanisms of third-party funding now. And it's become such a popular topic that I think one of our earlier speakers referred to the ICA study, a very large and very detailed study that took a couple of years into the use of third-party funding in international arbitration. Again, I thought this was just interesting. This is just one company, who most of you will be familiar with, Varnum, their approach and the sort of cases that they're currently funding. So Varnum are a very significant funder, and obviously with operations both here in Australia and in other jurisdictions. They disclose publicly that on average about $6.4 million is what they are committing. But look at the cases that they're funding in the context of quantum. 100, 145, 220, 200, 300. So very significant cases. And again, look at the industries that we're talking about. Everything from finance to defence to mining, etc. They range across a number of different venues. So large sums involved, significant funding, but if you compared that to the funding of a class action here in Australia, not madly different in the context of the amount of funding that would be required to run a significant class action. So that's all the situation if you looked at it from a world perspective. But what about our region? And the most significant thing that's occurred just in the last 2 years is the changing rules in Hong Kong and Singapore, which, as much as we love Sydney and as much as we want to see Sydney thrive as an arbitration centre, the fact is that Hong Kong and Singapore deal with still the bulk of international arbitrations in our region. And obviously China, the institutions that our earlier speaker referred to, are also taking up a large number of disputes. So we want to draw more of these disputes into Australia. Singapore and Hong Kong, however, are, probably you could say increasingly have been, are very favoured locations for international arbitration. And you go, well, that's fine, that's the status quo. But what's changed is that the attitude of those two jurisdictions has changed just in the last year or so concerning third-party funding. So they've freed up the rules in relation to third-party funding. They've made it a more attractive place for funders to be, and they are flooding in. So, and this is particularly in relation to arbitration. These two sets of stats give you a very clear idea about where they rank in the context of international arbitration. Top 5 seats, 22% of international commercial arbitration occurs in Hong Kong, etc. So strong seats, likely to become stronger now that they have freed up the rules and regulations in relation to third-party funding for arbitration. What about Australia? It's an open market in the context of funding for arbitration, so nothing that would make Australia an unattractive venue for a funder to fund a large-scale international arbitration. It has many advantages in the context of arbitration. It's a very attractive arbitration venue, and it is certainly being used. There was a survey that was published just about a month or so ago that dealt with just the West Australian arbitration market. And that survey displayed huge growth, predominantly obviously in the mining industry, but huge growth in arbitration. And Perth representing as a very real threat to arbitrations that traditionally have flowed up into Singapore and Hong Kong. So, yes. There are, however, and this is nothing different in arbitration to what we see in litigation, there's obvious tensions in the context of arbitration funding by third parties. And the funding issues can be many and diverse. You have the normal funding issues that relate to, take a scenario where you have an arbitrator. The arbitrator is aware of the third-party funder being involved in an earlier arbitration case with a particular law firm he may be aware of. Same law firm turns up in a new arbitration, and the arbitrator thinks, well, it's highly likely that this claimant is also being third-party funded. Then someone makes an application for security for costs against that claimant. And in those, normally, particularly in an investment treaty case, security for costs is refused. It's much harder to get security for costs against a claimant in investment treaty cases. But what if the arbitrator goes, well, I know that this party is being funded, so the normal rule about, oh, well, I shouldn't penalise the claimant whose position is in the poor state that it is due to the actions of the respondent. But in this circumstance, I go, well, actually, the claimant is but a shell for a third-party funder who will be covering all of the costs, including any adverse cost orders. Does that colour the approach that the arbitrator may take? Most modern arbitration rules now require the disclosure by a party if there's third-party funding. So you can't sit there and silently not disclose the existence of third-party funding. And there are arguments for and against whether that disclosure ought to be made. But the fact is, if you're arbitrating under the rules of these arbitration institutions, you must disclose. The Hong Kong Code, the one that I've just referred to, talks about control over the extent of influence available to funders. Clearly, whose case is this? Is this a case being run by the claimant, or is it a case being run by the funder? Procedural requirements for management, disclosure, as I've just said, of third-party funding agreements. And the survey that was conducted, I think in conjunction with the review of that legislation, certainly indicated most parties say that there needs to be some control in relation to the influence of third-party funders. As a final point in relation to this topic, there's sort of, if you like, the interesting sub-point that relates to, here I am, I'm a third-party funder, and I have an agreement with a claimant. How do I then address a question of if there's a dispute between me and the party that I'm funding? Particularly if that's a dispute in this scenario, which is being conducted in a cross-border context. And certainly what this author recommends, and I've got to adopt those recommendations, is you need to have within your funding agreement have an arbitration clause. Because the dispute between you and the claimant needs to be from time to time resolved. It might be a disagreement as to settlement, it may be a disagreement in relation to various circumstances that have emerged. And in those circumstances, what you should be doing is including an appropriately drafted arbitration clause. So that was all that I wanted to touch on today. I wanted to do that general topic of why you can you should use arbitration and use third-party funding in the context of arbitration. So thank you. Thank you very much.
Any question?
Yeah.
How do you think about the cost of this third-party funding? Maybe the premium that is recovered after the disputes. So your opinion, would that be allocated to another party or the party who breached the contract?
Yeah.
Or would just bear by the party who applied for the third-party funding?
Yeah. There's been some.
Repeat the question, I'm sorry.
Sorry. I was just asked about what happens in relation to the premium that occurs where a party obtains third-party funding, and does that form part of the award, or who has to pay for it? And there's been some recent cases that dealt with disputes about where an arbitrator said, I see as part of the cost of bringing this arbitration, it was necessary for you to get third-party funding, and that you had to pay for, after the event, insurance. There was a premium that was paid, so it may have been your share, whether it's 10% or 30% of the award, and the arbitrator said, yep, I see that as legitimate, and I will allocate extra within the arbitration award to compensate you for that, so that you're not out of pocket at all in relation to damages. And a challenge to that before the English courts was unsuccessful. So yeah, it's been an interesting component in the way that courts are endorsing an approach towards third-party funding within arbitration. Yeah. Any other questions?
All right, guys.
Very good. Thank you.
Thanks a lot.
Bye.